Good afternoon. Your Excellencies, distinguished candidates, ladies and gentlemen, it's my honor to welcome you to the third panel discussion with candidates for the ICC Judicial Bench. My name is Kirsten Meerschaert, and I'm the Director of Programs with the Coalition for the International Criminal Court. The Coalition is a network of more than 2,500 non-governmental organizations from 150 countries, working in partnership to ensure that the court is fair, effective, and independent, to make justice both visible and universal, to strengthen international cooperation with the International Criminal Court, and to advance stronger national laws that deliver justice to victims of war crimes, crimes against humanity, and genocide. I would like to express our deep appreciation once again to the host state of the Netherlands for hosting today's panel discussions. Thank you again, Ambassador van Ijssel, and all of the colleagues at the Ministry of Foreign Affairs for arranging this venue for our meeting. I would also like to thank all of the candidates who have joined us so far today, and also the candidates in our third and final session. These discussions seek to enable the nominees to expand on their respective qualifications and expertise, as well as to promote fully informed decision-making by state parties delegates. English and French interpretation is available, and I would already like to thank the interpreters for their assistance here today. And today's event is being recorded and live streamed, so those watching from afar may join in the discussion on Twitter by using our Twitter handle at NGOs for Justice and the hashtags #ICC elections and #ElectTheBest. I would like to emphasize that today's event, and again this third panel, is an independent event of the Coalition for the ICC, even though we are currently in the ministry's location. Indeed, today's event is part of a long-standing and comprehensive campaign by the Coalition for the International Criminal Court, in the firm belief that the International Criminal Court will only be seen as truly independent, fair, and effective in adjudicating international crimes if its chambers are composed of only the most highly qualified judges. Since the court's first judicial elections in 2003, the Coalition has worked to raise awareness and understanding about the ICC elections and the candidates, including by preparing detailed fact sheets about the nominations and elections processes. At the 16th session of the Assembly of States Parties this December in New York, 6 new judges will be elected to the ICC bench. As such, we like to think that today's panel's discussions provide an opportunity for all to learn more about the candidates' qualifications, experience, and expectations for international justice. In addition to today's panel discussions, the Coalition has asked all nominees to fill out questionnaires that provide additional information about their qualifications. The responses to these questionnaires are available on the Coalition's website at www.coalitionfortheicc.org. I would like to stress that the Coalition as a whole does not endorse nor oppose individual candidates, but we advocate for the integrity of the nomination and election process. As such, the Coalition strongly opposes reciprocal political agreements or vote trading in ICC elections. In a moment, I will ask the candidates to briefly introduce themselves, and then I will open up the floor to questions from the audience. When we move to the Q&A portion, I would kindly ask that those requesting the floor refrain from making statements or comments and simply pose focused questions addressed to the entire panel. I would also exhort you to not ask the candidates anything pertaining to a preliminary examination, an investigation, case, or any other matters sub judice before the ICC or potentially before the ICC. So I will now invite the candidates to provide a brief introductory remarks, and I would like to start with Ms. Peralta Distéfano.
Hello, everybody. Thank you very much for being here tonight. It's a pleasure to for me to be in your presence tonight in The Hague. I really appreciate that you take your time to come here, and I want to also thanks the coalition for this opportunity for all of us to present our commitment, our experience, our knowledge, to share with you, to answer questions. And congratulations to my colleagues in the previous roundtables, and right now that they are sharing for me to this this promise or this dream to be a part of the ICC as ICC candidates. Thank you very much for all of you. I want to clarify that I am a candidate for List B. So I'm not a judge, neither a prosecutor. I was appointed by Uruguay, República Oriental del Uruguay, and I'm going to take a few minutes of your time to sharing with you my professional life, my capacity, my knowledge, my experience. When I was enrolled in the law school in Uruguay, my country were under the oppression of a dictatorship, and I was one of the youngest professional lawyer that contribute to put my knowledge and my capacity in serve to reconstruct the social fabric of Uruguay at that time, which was extremely necessary. That was how I start my life as an advocate, as a human rights lawyer. I was enrolled in a non-governmental organization, which is the broadest in my country to provide until today with legal counsel to victims of violation of human rights. And I was the director for the organization for 10 years, the Service for Justice and Peace. After 10 years, I'm representing victims and providing justice. I was working in the capacity of Secretary Executive of the same organization for the whole Latin America. My passion for international law led to me to pursue studies abroad my country, and I studied here in the Hague Academy in Geneva, in other institutes in Latin America, and I was awarded by the prestigious Hubert Humphrey, where I studied a master in law, in international legal study with a focus in international law, protection of human rights, transitional justice and state accountability in Washington College of Law, American University, Washington, D.C. Before studying in the United States, I was the director for the Americas for the Association for the Prevention of Torture based in Geneva, Switzerland. And my task at that time was to outreach a state for ratifying the OPCAT for the Convention of Torture. That experience gave me with a lot of knowledge about or skill, diplomatic skill, and how to outreach for the best causes other states and stakeholders. When I finished my master's degree, I returned to my country, Uruguay, because I was hired as a national consultant on human rights and legislative policy in Uruguay under a special program at that time running by the United Nations Development Program. And my task was to enhancing and enforcing the capacity of legislators in the human rights field. Afterward, the Center for Justice and International Law hired me and offered me the position as a deputy director based in Washington, D.C., and I took the position, and I was leading in tandem with the executive director, the institution, for almost 8 years. The Center for Justice and International Law is one of the most prestigious non-governmental, non-profit organization, which one of its aim is to provide representation for victims of gross violation along the Americas, from North America all the way, and the Caribbean also, before the Inter-American Commission and the Inter-American Court of Human Rights. That's given me with a huge experience of being in courtrooms, litigate cases on a various legal violation and legal arguments in complex crimes, such as a situation where, in situation of armed conflict, disproportionate use of armed forces, enforced disappearances, mistreatment and torture, also the protection of women and girls, women that suffer domestic violence and women that suffer other violation during armed conflict, displaced person. And so I have a wide experience in litigating, in being in a courtroom and understand all the equivalent of arms and all the procedures that we have to take into account in a courtroom, bear in mind all the guarantee for the accused person or the accused state in the case of the Inter-American system, and the participation and the guarantee for participate and for reparation for the victims. While I was I not only have that experience on litigating, but also I led the institution and trying to make more efficient, more transparent, and more accessible the Inter-American system of human rights. I work, as I mentioned, I have a vision of the regional system and the global system working in Europe and in the Americas. In 2012, I was nominated to serve in the first board of the National Institution of Human Rights in its first mandate in Uruguay, in my country, and I was elected by the Congress. So I returned to Uruguay. I served for the inhabitant of Uruguay for 5 years as one of the members of the board of the National Institution of Human Rights, ended my mandate as the chairperson of the institution in August 31st, 2017. Among others, institutions, board, and foundation that I am a member or a member of the board, I'm also a member of the Mandela Dialogue on Memory Work with opinion leaders and change agents representing 11 countries to deal with memory work in different societies that suffer atrocities. And I'm a trainer and a member of the Latin American Network to prevent genocide and mass atrocities. Procuring reparation to victims of brutal atrocity and to their communities and families has been my life option. Now I think I can bring different perspective, experience. I work in different capacity, and I would like to make a difference by being part of a unique institution and organ as is the ICC, with a platform for the whole world. A platform that was created for the very same purpose, an organ that is, after 15 years, is working, is not only just is functional, there's a lot of challenge that probably we want to talk about that later, but it's in function, just settled jurisprudence, and it's also a hope for the atrocity around the world, in a troubled world that we live. And my hope, my dream is that the ICC could come one day to be a typing point to change the behaviors of what people think about the atrocities that are committed today. So I'm ready. I'm going to put my commitment, my experience, my knowledge, and my passion to work as a judge if I have the honor to be elected. Thank you very much.
Thank you, Ms. Peralta. Distéfano.
Thank you very much, and good afternoon to everyone. I'm Kimberly Prost. I'm nominated under List A by my country, Canada. I'd like to start by joining in the thanks to the Dutch government for offering this amazing room for the discussions this afternoon, and to the CICC, of course, for organizing this time-honored tradition of panel discussions amongst ICC judicial candidates, which is so essential to the transparency of this election process. I'm very pleased to participate and look forward to engaging with all of you and with my fellow panelists. I'm going to combine my introduction with the description of my motivation as they are entirely interrelated. I've had a career of over 35 years, almost exclusively as a practitioner in the field of criminal law, and in particular, international criminal law, both domestically in Canada and internationally with 5 different organizations. But it is more than just my field of work. From what I've done, from what I've seen, I am passionate about justice, about redress for victims, and about accountability, but equally about the need for all of those goals to be attained through a legal system with fair process and in accordance with the rule of law. At this stage of my career, I want to use my experience, the experience I've gained, the skills that I have, to support an institution which is, in my view, fundamental in that respect, the International Criminal Court and the Rome Statute system of international criminal justice more broadly. And I believe that my background would allow me to make the strongest contribution to the court as a judge, especially at this critical stage where the court is heavily occupied with its core judicial mandate. You have my CV, and the questionnaire, so I leave you to assess the details in that regard. I just want to highlight 3 points. In terms of the core functions of an ICC judge, the day-to-day work, the everyday work, I believe I have extensive, relevant experience in and around the courtroom. I've served as an ICTY judge on a 4-year multi-accused trial, and as well on related proceedings as a presiding judge and as a pretrial judge. I was for many years in Canada a line prosecutor, day in, day out in court, with a whole range of criminal offenses within the jurisdiction of the federal government. And I worked for a portion of that service as a prosecutor in the field of war crimes and crimes against humanity specifically, and I appeared at all levels of the Canadian courts. I have also most recently used all of the same skills in a quasi-judicial position, having served for 5 years as the ombudsperson for the Security Council Al-Qaeda Sanctions Committee. In addition to bringing that practice experience, I also have a very specialized knowledge of the ICC legal framework, having participated in the negotiation of the Rome Statute and its rules of procedure and evidence. I also had the interesting opportunity when I was with the Commonwealth Secretariat to prepare a manual and model implementing legislation for common law states for implementation of the Rome Statute, and to follow it up with a series of pan-Commonwealth workshops where implementation was discussed in Africa, in Asia, in the Pacific, and in the Caribbean. And most recently, I have exposure to the operations of the court, as a court, in my role as chef de cabinet to the President. Lastly, I have worked for many years in the field of international cooperation in criminal matters, extradition, mutual legal assistance. I have, in fact, been categorized, probably correctly, as an international cooperation geek. This has given me additional experience in terms of the construction and management of complex international cases, but also importantly, while I come from a common law tradition, I have gained considerable understanding of and appreciation for the other legal systems and traditions in the world. And I believe this knowledge would serve me very well as a judge of this truly hybrid international criminal court, especially at a time when it needs to find and solidify best practices. In conclusion, I am honored to have been nominated for election to this institution I strongly believe in. I'm motivated to serve, and I believe I have the right skills and experience to make a strong contribution to it. I'm happy to share and exchange with you on my ideas related to the court and, of course, to respond to your questions. Thank you very much.
Thank you, Ms. Prost. Ms. Mensa-Bonsu.
Thank you very much. Let me add my voice to the comments made by my colleagues earlier and express gratitude to the government of the Netherlands for this platform and the CICC for offering us the opportunity to introduce ourselves to you. I'm equally grateful that you have stayed the entire day just to be with us. If there had not been an audience for us, we might have been a little demoralized. And so I am thankful to you that you have stayed throughout the day for this. I'm honored to be Ghana's candidate for the position because of the experience and the skills that my country agrees that this body could benefit from. I come to this position from a variety of angles. First, through transitional justice. I was a commissioner in Ghana's National Reconciliation Commission, and thereafter I became an advisor to the Liberian Truth and Reconciliation Commission, and got recruited into the UN, and I was appointed the Deputy Special Representative of the Secretary General for Rule of Law. But before then, my earliest association with the ICC, at the time I did not know was prophetic, but the Ghana Bar nominated me to serve on an International Bar Association group looking at giving advice as to the setting up of the Defense Council and the arrangements for Defense Council appearing before the ICC. This was soon after the treaty was signed. I've had experience also at the international criminal justice level because I was a member of the Committee of Eminent Jurists that the then OAU set up to look at the Lockerbie case and Libya's situation. Then I was also a member of the Committee of Eminent Jurists to look at the Hissène Habré case for the African Union. And it was our committee that recommended that Senegal should be made to try Hissène Habré for the crimes that he had committed against his people. The reason was that Africa needed to show very strongly its disgust for certain kinds of behavior and not to appear to be shielding its own when it came to victimizing one's own citizens. With this kind of background and with my work in transitional justice, heading the UN's effort in Liberia to help reconstruct the legal sector in post-conflict Liberia came in handy. I was head of a section that had the human rights section, the corrections section, the police, and the legal and judicial sector proper. And our task was to help rebuild the sector and to enable Liberia overcome some of the difficulties that a broken system had caused them, and for them to be able to move on. And this I did for 4 years. And I'm happy to say that many of the initiatives I spearheaded have borne fruit, and the mission is about to close. In 2014, I was appointed by the Secretary General onto the panel of high-level panel on an independent panel on peace operations, because as you all know, the consensus around peacekeeping has been a bit fractured, and there was a need to look again at the practices and the principles and the issues, and to help the UN chart its way forward, because the ground has so shifted that the original ideas about peacekeeping did not seem to be doing very well. And so we spent about 8 months looking at all aspects of peacekeeping and peace operations, particularly the preventive aspect. So all of these things have caused me to wonder whether putting my efforts behind efforts that help with prevention wouldn't yield more for the victims than some of the other initiatives. It's all very well to set up things to look at people's issues after the problem, but it does seem that looking at the dissatisfaction of people when they have to get into a transitional justice mechanism such as a Truth and Reconciliation Commission, rather than seeing their perpetrators punished, I began to wonder whether there wasn't something at the other end that I might apply myself to with the skills and the background that I have. And it is these that have propelled me to step forward to offer myself to do, to help this noble institution chart its way into the future. Thank you.
Thank you, Ms. Mensa-Bonsu. And now to Mr. Aitala.
Excellencies, dear friends and colleagues, good afternoon. I'm very grateful to the Dutch government for hosting us in this beautiful room, and to the coalition. I'm very grateful to the coalition not only for the invitation, but also, since it's the first time I meet with them, but been following their work, for what they've done these 22 years. They have inspired several people, political leaders, but also humble jurists like me. And they have united, I think they have united many people, hundreds of thousands of people, around the idea of human dignity. In these few minutes I have at my disposal, I will speak quite a little about what I've done. It's in my CV. I would like to share a couple of ideas and why I really feel like I'd like to be part of this institution. You know, the time we are living, it's quite a difficult time. It's the main feature of our time is fragmentation. Political institutions are tearing apart in several parts of the world. Political alliances struggle to do their work. And I think that the ICC not only is an organ of justice, it is also a place where 124 states of this world are united in the name of human dignity, in the name of human rights against atrocities. Personally, I've been always very passionate about criminal law and human rights. This was something I started when I was a boy, but at the beginning I was quite confused. My mother tells me, she's 87 years old, she tells me that I used always to say, I want to help people who are suffering, people who are being abused, but it wasn't quite clear to me if I want to be a medical doctor or a defense lawyer, police officer, I don't know. I didn't know at the time. When it was time to choose university, I'm from Sicily. Sicily was overwhelmed by violence, intimidation. The mafia was really about to change the shape of our state. It didn't manage to do this, but this shocked me very much. In 1984, I was about to choose to go to University of Medicine, but then a journalist who was writing inquiries about the mafia was killed, and it was near my home. I was so shocked that I went to the university, and when I came back, I told my mom, I joined law. She said, wow, weren't you going to join medicine? I said, no, I changed my mind. I want to be part of this. I don't feel like ignoring it. And my encounter with criminal law was later when I started studies. Civil law in Italy is very important because, civil law is based on Roman law. It were the Romans who invented the idea of law and the idea of civil law. But criminal law has to do with human beings. Civil law has to do mainly with interest, with business. Criminal law has to do with us, with our madness, with our feelings, our sentiments, our love, our hatred. And this is probably why I was so attracted to criminal law. And then one day, years later, I met Antonio Cassese, Nino, and I was already very keen on international criminal law, but when I met him, then I understood it was something that I had to do sooner or later. His book, I have it with me here, his first book on international criminal law, was like almost a sacred book to me. I was reading and reading it so many times. One thing I would like to add about my experience, which is not reflected in my CV, is that at the end of May, I have returned to the judiciary. I have left the Senate, where I was the senior officer, the senior advisor to the president of the Senate, who is our second highest authority, and I've returned to the judiciary. I just wanted to prepare for this experience, for this candidacy. I'm now back in the prosecution office in Rome. I'm a senior prosecutor. I'm dealing with international terrorism and international offenses. In our system, offenses committed abroad by Italian citizens or against Italian citizens are the competence of the office of the prosecutor in Rome. And this is why I've chosen this office, and I'm dealing with piracy and other international offenses. Let me go towards the end. Again, as I said, I'm not going to give any detail now about my CV. I'm very happy to answer any question later on. I would only end up by saying why I really feel like being part of the ICC. A few days ago, if you allow me telling a very short story, a friend of mine invited him for dinner because his son is finishing his studies in law. And he was asking me, he calls me uncle, Zio Rosario, Uncle Rosario, what is the most difficult thing of your job? And I asked him, you tell me, you guess. And he says, is it insecurity? Because he knows that I've been exposed to several threats, living with bodyguards, things like this. And I told him, no, because this is something that comes with the job. I told him it's like being a Formula One pilot. You know that at next bend you may lose your life, but still you're speeding and you're going fast, the faster you can, because you want to challenge yourself. And then he said, is it about workload? Because he knows that I wake up like 6 in the morning, I work all day. And I told him, no, because this is quite obvious, if you love your job, you do it for as long as you need. I told him, and really I feel it, the most difficult thing of being a judge is confronting with human suffering. You cannot allow to be overwhelmed by these feelings, because if you want to be a good judge, you cannot be part of someone else's suffering, Compassion. Compassion comes from Latin, from compatire, which means suffering together. So you do have compassion, but you cannot be overwhelmed by it. But you never get used to it. When I think especially to the first case in my life was the murder of a small boy. He was maybe 5 or 6 years old. He had been abused for 2 years and then killed by this horrible animal. I wouldn't even call him a man. And I kind of forget it. It's like being a medical doctor. You never get used to that. I asked a friend of mine who's a surgeon, and he told me, when I do my work, I try to be as cold as I can, but I never get used to that, because anytime one of my patients dies, I feel like crying. And I think that this is really what we need to do as judges. We need to stick to the procedure, stick to the law, but at the same time, we need to allow ourselves to become those who are giving compassion to the victims. And I'm finishing, the International Criminal Court cannot get rid of all atrocities, the world. It can't do this. It will deal with certain number of proceedings, 5, 10, 20, 100. But what we can do, what the court can do, is giving hope to those who have lost hope, because they resort to authorities who very often are those who are abusing them. And what we can do is giving redress, giving the victims the hope that there will be an independent and impartial place where their reasons will be heard and their stories will be told. Thank you.
Thank you, Mr. Aitala. Thank you to all the candidates for your introductory remarks. I'm now pleased to open the floor to questions. And just a brief reminder that if you could keep your questions focused, short, to the point, and yet also address them to all of the candidates so they have an equal opportunity to answer. So, if you're, yes, please.
Good afternoon. My name is Mariana Pena. I work for the organization, the Open Society Foundations. It's first of all, it's an honor to be here and have an opportunity to interact with you. I'd like to ask a question picking up from the last remark on victims and victim suffering. As we all know, the Rome Statute includes innovative, unique provisions on participation of victims in proceedings. And I'm aware that different candidates to the position of judge may have had different experiences in working in different systems, allowing for victims' intervention in proceedings. So my question actually has two parts. The first part is what skills and qualifications do you bring to the position of judge and you would be relying on for the interpretation of victims' participation provisions? What specific part of your background will you bring to bear in that respect? And the second part of my question is, what do you, from the position you are now, perceive to be the greatest challenges for a judge to facilitate victim participation in proceedings, considering, among other things, the distance between The Hague and the places where the victims are located, the fact that judges normally don't have an opportunity to go to those places. So in essence, what do you perceive to be the greatest challenges to make the proceedings accessible to those communities? Thank you.
Thank you. So just to recap, the question relates to the participation of victims in proceedings before the International Criminal Court, and all candidates are asked to weigh in on their particular skills and qualifications regarding the interpretation of victims' participation provisions in the Rome Statute and in the ICC system. And the second part of the question relates to the challenges you may foresee for an ICC judge to facilitate victims' participation, notably given the, among others, the issue of distance to those affected communities. I'm going to ask Mr. Aitala to address this first question first.
Yes, thank you very much. As a prosecutor and before also as a police officer, I've been involved in many proceedings. In our system, victims have a very key standing. They're allowed to sit in court, they're allowed to present evidence, they're allowed to make questions, and they always are allowed to get reparation within the same criminal trial. So it is a routine for us, the consideration of victims. Let me add on a specific category of victims that are vulnerable persons, that this implies also additional challenges. One is, for example, dealing with victims who are also witnesses, so getting their testimonies. In our system, and I believe in many systems in the world, there are a number of safeguards to avoid, on the one hand, to harm the victims by recalling what they've gone through. On the other hand, the need of making sure that their testimony is genuine. For example, when victims are children, this could be very difficult. So I normally ask and resort to the help of psychologists, experts, and this is very important to understand how to make questions, what questions to make, and avoiding, again, for example, on children, children sometimes do fabricate stories, or in other cases, they're not able to tell stories because the trauma has been too intense and too deep. In our system, also, whenever the victim or a witness, a key witness, is a child, parties, the prosecution and the defense are not allowed to make questions directly, but they need to go through the judge. The judge makes an evaluation of whether the question is well posed or the question is dangerous for the child, and then makes the question. And there is always a psychologist sitting in these proceedings. And additionally, normally, when the proceeding is about sexual violence or other kind of atrocities against vulnerable persons, these testimonies are taken outside the court. Of course, there is a judge, there is a prosecutor, there is the defense. All rights are completely guaranteed, but there isn't any public. The environment is adapted to the person. If it's a child, it wouldn't be a room like this, which may scare a child, and so on and so forth. I had the opportunity of measuring with the issue of victims also in my international experience. For example, when I arrived in Afghanistan, it was a very difficult time. The war was very violent, but I realized that most children had no representation in court, especially when the author of the abuses was the father, because the legal representation, of course, was with the father. So what we did together with our Afghan friends, we established in the prosecution in Kabul and in Herat 2 sections for violence against women and children, to specialized prosecutors, and allow them to acquire a proper way of dealing with these offenses, which is completely different from terrorism or drug trafficking or robbery. And on the other hand, what we did, we set up an Afghan NGO with Italian funding in order to give legal assistance to anyone who needed it, not only the poor, but especially women who had been abandoned or children who were abandoned and had no opportunity of getting a serious defense. So they would go by routine every day in all police stations to see whether any child or any elderly or any woman in trouble had been arrested, and they would discuss with the authorities to see whether there were grounds, legal grounds, and so on and so forth. And this was very instructive. I have to say that the Afghan colleagues were wonderful because they did understand how sensitive it was, and I think this was a big step. The challenge, and then I finish, the challenge for the court, for those who will sit in the court, and I wish my colleagues who are in extremely high level all the best in this respect, is to make the court effective. You know, as I mentioned earlier, the court cannot adjudicate all atrocities, all international crime. This is not possible, but what we can do is having the people throughout the world understanding that there is a judge even where local authorities are unwilling or unable to act. So it is giving a hope, and at the same time it is about having the people feeling the court as something which belongs to them. And this is why the victims are crucial, because we are dealing with international crime, and we all know that when the doctrine of international crime emerged, it was revolutionary in international law, because until that time responsibility was only with states, not with individuals. The idea was that after the Second World War, after what we had seen in Europe, in Italy, in the Balkans, in Asia, the international community said, never again. We will not allow to see anything like this again, and we will call to individual responsibility also those who were committed or ordered the commission of atrocities, not only states. This was revolutionary. Until that time, it was unheard of. And if this is international criminal law, then we need to give a voice to the victims, because those victims are the entire humanity. In the moment when you have in a trial a victim of international crime, you have before the bench a victim which represents the entire humanity. And this is why I think the statute is very well conceived in this respect. And I'm sure that the excellent judges who are already sitting in the bench and the new judges who you as member state parties will elect will make sure to make this court as the court of humanity, which means also the court of victims.
Thank you, Mr. Aitala. Ms. Mensa-Bonsu, same question.
Thank you very much. As somebody who has taught criminal law and procedure and written quite a bit on those matters in Ghana, I'm quite familiar with the overhang of unassuaged pain that victims have, because sometimes the system excludes them altogether. Indeed, the movement to develop victim offender mediation processes within the criminal justice system have been fed by such feelings that people who have suffered appear to be shunted to the side, while other people who have not suffered take center stage. And they think that if people heard what had been done to them, meant to them, perhaps things would be different. Being cognizant of these feelings and having worked on truth and reconciliation processes, which are essentially victim-centered and which seek to assuage the pain of the victims and to give them back their dignity, it does seem to me that a very good aspect of the statute is the platform it provides for victims to participate. And I think that it's the responsibility of the judges to make it as functional as possible, and also to be aware of the downsides. You don't want more than one prosecutor. It causes confusion. At the same time, if people are entitled to have their voices heard, then structured ways in which they can participate would be meaningful. I know that some of these things have already gone on in the court, and I applaud the efforts that has been made so far. I think that particularly for people coming from very remote areas in Africa, this kind of room is a world away from their experience. And so also it would be that perhaps the judges may empathize, but will have no real idea what the lives of these victims are. Sometimes we underestimate the atmosphere of fear that still remains in these places where matters come up before the court. And the victims are so afraid that sometimes they don't even want to be known as victims. And so if some step forward and come into the process, then they do represent a group larger than they themselves perhaps might even be aware. And it's important to incorporate their voices. At the same time, there's so much technology now. This panel discussion is being streamed live. There's so much now to involve victim populations, so that even if they dare not step forward to testify or to participate in the trial, hearing what is going on a day-to-day basis, or seeing the people they once thought were so powerful nothing could bring them to book, has in itself a healing element for them. And so I think that the provisions are there. Every effort will be made, certainly if I have anything to do with it, to make victims feel that it is about them as much as it is about the accused persons, balancing their interests so that each one comes out of it with the best possible result would be my aim. Thank you.
Thank you, Ms. Mensa-Bonsu. Ms. Prost.
Thank you. If I could respond first to the first component of your question as to what skills or qualifications I would bring to the particular issue of participation, and I would include as well the reparations component of the Rome Statute. I come, I suppose, with a bit of a negative reverse qualification or skills, because I come from a system, the common law system, where one of the, I think, most valid criticisms of the system is the fact that it has not paid significant attention to the question of victim participation and to the victim aspect. And similarly, having worked at the ICTY as a judge, that is one of the critiques that was properly rendered in terms of the ICTY and the ICTR, the absence of that important component. So what those experiences, having practiced in those systems, has taught me, and the awareness I would bring, is of the importance of the participation system in making it effective. I also was completely unfamiliar with the participation system until I participated in the negotiations, and I've had the benefit of the passionate arguments that were advanced in Rome and beforehand as to why that was such an important component, which has been proven to be absolutely the case. I now see also and fully appreciate how important the restorative justice component of the Rome Statute is to the very credibility of the institution. So what I would bring, I believe, is a strong support for, understanding of, and belief in the system and how it should operate. The challenges are, unfortunately, there are many. First and foremost, there is achieving that balance it's important that we have a real participation system, that the victims feel that they are a part of the process, but at the same time, the rights of the accused must be respected, and there are limitations in terms of time that can be given for that component, especially at a time when the efficiency is of such import. So it's, in each case, it's for the judges to make sure they're choosing the appropriate interventions in terms of the victim's participation, and that they're achieving that balance. Each case, each issue, that is a significant challenge for the judiciary. One of the most important issues, I think, right now for the court, one of the ways in which this can be most effective is through a proper legal representation system. And there are very significant issues right now. Human Rights Watch has just issued a very interesting report on the issues surrounding how legal representation is selected, and the need for the victims to feel that they have their representatives, and at the same time that they have their voice, but at the same time we face the realities, the fiscal realities, and the practical realities of achieving what was set out in the Rome Statute in terms of a process for selecting victim representatives. So I think that's an area that requires significant attention, and it must be led by the judiciary. And then there is, of course, as you've identified, the fact that these trials are taking place far away from the situation, from the crimes, and that's why there has to be outreach. The court has worked very much in the past few years on outreach, but I think it falls to, again, to the judiciary for each of the cases to early on be consulting with the registry on the questions of consultation and outreach to the victims. For the Ongwen trial, by example, there was efforts made at the opening of the trial in terms both of bringing representatives to the court and sending representatives of the court to the situation country. So those challenges, again, with constraints on finances, also have to be something that are the focus of the judges in each and every case. So that would be, I think, some of the key challenges I would see. But again, it is such an important part of the Rome Statute system that there are challenges that we have to address and meet in each and every case. Thank you.
Thank you, Ms. Prost. Ms. Peralta, Distéfano?
Yes, thank you very much. Thank you for the question. I will try to address in the two parts of the question. The first part about my qualification or skill for interpretation of victim participation. I think I have a lot of experience. My whole life was representing victim before at the internal, at the domestic level, at the international level, especially in the Inter-American system. I think before the Rome Statute was entered into force or was drafted, the Inter-American system was extremely was pioneer in terms of victim reparation. And I work along with victims since the first stage, in first hands, on the ground, before they face the trial, getting all the support, skills, sensitivity, approaching a central victim criteria to protect the victim and to protect their rights and the participation in the hearings, and even after that, after when reparation were granted, and how to in a way that I work after the judgment with the victim in terms of the implementation of the sentence and the reparation that was given in the sentence. So I think I particularly have a lot of experience in victim participation, working along with them all the way. And what is about the greatest challenge, especially that the ICC face in terms of victim participation? First of all, the Rome Statute was extremely revolutionary in terms of victim participation. It was the first international instrument that established the participation of the victim since the early stage and after the reparations. So it's really the only international instrument that granted the victims that possibility of participating. I know I'm very aware that it has been conflicting, it has been challenging, that the participation of victims has been far from easy. And as you mentioned, there's a lot of victims in a remote place, probably several times in conflict zone, with a lot of difficulties in terms of communication, illiteracy, or really, really far to the access to the court. I think there's some things that could help in a better participation of victims. One is the court is addressing this, and it's when the Assembly for State Parties asked the court to raise some data for indicator, qualitative and quantitative indicator, and one of the in between the four concern of that the court set up for constructing those indicators is about victim protection and victim access to the ICC. So this is there in place. This is a working process. The other thing is protection of the victim. Sometimes it's extremely difficult, and it's a reality because some of the victims are under threat. Serious threats need to be relocated or protecting by reduction of their statement, or by using a lot of other methodology to protect them. So this is something that the court need to keep in mind at the very beginning, as a very main thing for victim participation. For me, this is extremely important. There's those situations of dual witnesses that are victims and witnesses at the same time, and also, of course, the judges on the court need to keep in mind and be applying the guarantee of the accused person and have the balances that is extremely important for a fair trial. I think the participation of the victim have been progressive. The different chambers have been using different way of giving access to participation of victim, and I could see some progress in that trend. Lately, in a case that I'm not going to name, but there was a decision of the chamber to apply a sui generis way of participation of victim, trying to make the process easier and more accessible, and to keep an expeditious trial with the participation of the victim. So they found a new methodology that is trying to make it faster and with accessibility. And I think that it's working. It's a working process, and I think that the court is already aware or the chamber to find ways that the victim can participate, and also the joint representation for victims that can facilitate their participation, and also the role that the Office of Public Counsel for Victims can play.
Thank you, Ms. Peralta, Distéfano. Is there another question from the audience? Yes, please.
Thank you very much. Bridget Ender here from the Women's Initiatives for Gender Justice, and thank you to the CICC for this fantastic day and for doing such a great job in organising the panels. It's been really illuminating to hear all of the panelists, and we have, I think, a great crop of candidates for this election. I have two questions. Firstly, for those nominated under List A, if you could just clarify how many cases you have adjudicated as a judge, List A is broader than that, but we're specifically wanting to explore a little bit your experience directly as a judge. And then for all of the panelists, the credibility of the court currently and going forward is going to be critical for its success and for the acceptability of its jurisdiction. And in our view, that has two components, one being the selection of cases and the prosecutions and the quality of the judgments and jurisprudence, and secondly, the institutional integrity, and this is the part I'd like to ask you about. So your views and or your experience in ensuring the integrity of an institution, its propriety, its transparency, its compliance with its own rules and regulations, with resolutions of its governing bodies. And the importance of that, obviously, with respect to credibility, but in very practical ways, your experience and your thoughts on preserving or maintaining and strengthening institutional issues of institutional integrity with respect to a court, and in this case, the ICC. Thanks.
Thank you. So the first part of the question was directed to part of the panel, to those candidates that have been nominated under List A, to give some statistics, if you will, to the number of cases over which they have presided as judge. If I may also then invite those candidates who have been nominated under List B to weigh in on experience that they may have in a similar, let's say, setting, perhaps not in a courtroom, but their own experience as well, so that all candidates here on this panel may take the floor. The second part of the question relates to the issue of credibility of the International Criminal Court as an institution, and candidates are requested to share their views, perhaps their experience or expertise regarding maintaining and strengthening the integrity of institutions as regards transparency, compliance with internal policies, and so forth. I would like to give the floor for this question first to Ms. Prost.
Dealing with the first question, I would approach this in looking at the criteria, which of course includes experience as a judge, and as I would also include reference to prosecutorial and quasi-judicial involvement. But in terms of my judicial experience at the ICTY, it was one trial, but it was 7 accused, 4 years trial, and involved multiple counts of crimes against humanity, war crimes, and genocide related to the Srebrenica genocide. So in terms of the scope of the particular case, I think it provided me with experience and expertise in all of the issues that can arise in these particular types of cases, such as the ICC has before it, the procedural aspects, as well as the legal questions before the court. There were a multitude of legal questions. I also participated, not to conclusion, but at the pretrial phase of a related case where I was the pretrial judge for an unrepresented accused in a related matter. So that gave me exposure to all of the issues of preparing a case for trial, and particularly in the challenging circumstances of an unrepresented accused, and also briefly for presiding over that related case, which involved organizing all of the various steps that take place prior to trial. So purely sitting as a judge, that's the experience. But I would also note that as ombudsperson, where I was assessing cases essentially to a legal standard, the same precise skills utilized by a judge. I dealt with over 60 cases related to listings on the Al-Qaeda sanctions list. and hundreds of cases as a prosecutor and as a international cooperation, dealing with international cooperation cases over the years. Again, the same skills of assessing evidence, credibility, and managing the complexities of disclosure and the various aspects of the judicial process. Thanks.
Mr. Aitala.
Yeah, as for the first question, it's difficult to say. I think in these 25 years I've gone through hundreds or thousands of cases maybe. Let me add that in the Italian system, both judges and prosecutors belong to the judiciary. It's the same career path, the same safeguards of independence. So even the work of a prosecutor in Italy is, in a way, the work of a judge. It's not the work of the lawyer of the accusation, because a prosecutor, the first thing the prosecutor does is to assess the case, and if he or she believes that the case is ungrounded or there is no evidence, the prosecutor closes the case. Then if he believes that investigations should go ahead, then takes this further steps. This is to say that overall, as a judge, as a prosecutor, I've dealt with many cases. Regretfully, we have a very heavy workload in Italy in criminal justice. But let me also add that I consider relevant not much the quantity of cases, rather the quality of cases. I have worked very much on mafia cases, and I mean cases with 20, 30 defendants with hundreds, thousands of pages of evidence, intercepts, undercover evidence, 500 witnesses, and so on and so forth. So one trial like this could last 3 years. So there are colleagues who have, in the entire career, have had 3 or 4 cases. There have been so big cases that they've done more than 50 judges joined together. And I finish on the first question, also spent a long time in the courtroom, even when I was working as a consultant abroad. For example, in Albania, we established at that time the Serious Crime Court, which was a sort of anti-mafia court and a serious crime prosecution. So I was sitting in court with the colleagues to help them and coach them on how to handle these difficult cases. The same I did in Afghanistan with reference to what I was mentioning earlier, especially in cases against of crimes against vulnerable persons. About the second question, integrity, credibility. Well, let me say, integrity is, let's say, the DNA of a judge. If a judge is independent and impartial, of course, integrity comes with it. I imagine you refer also with the kind of image we give out to the outer world, we give to the people and the world. I think that's one of the ingredients for this credibility is efficiency. And I think that we all share in this panel the feeling that the ICC will need to become more efficient, more expeditious, while of course fully, and I repeat 3 times, fully allowing right to a defense. It is possible to make trials faster if the judges do their job. And in my view and my experience, the job of a judge is making sure that the trial stays within the right track, that witnesses talk about the issues concerned, not other issues, and so on and so forth. So one ingredient of credibility is definitely efficiency. And the other is I believe, respects for the rights of the defendant. I refer again to my experience with mafia. You know that this kind of offenses, in a way, are not that different in their essence from international crime because they involve very much society. They have also a cultural and social feature. So it is very important that you show everyone, defendants, and also those who belong to the same criminal organization that we are opposing, that a trial is not vengeance, but a trial is justice. It means that we do follow the evidence, we do respect 100% at all times criminal procedure. And this comes again to the point I was raising at the beginning. Being a prosecutor in my country involves also, like in the ICC, the obligation to seek for evidence in favor of the accused. Because we don't start with the idea that the defendant is guilty, we need to have the evidence being built before the eyes of the court. This is the work of a judge. And I think that when a court acts according to the rules and with full respect of defense rights and the rights of all the parties involved, including victims, this is the best evidence that the court is acting with integrity, with credibility, and with compliance to the rules.
Thank you, Mr. Aitala. I'm just going to let Ms. Prost weigh in on the second question.
Yes, sorry, I thought it was a divided approach. So let me comment on the question of institution protecting integrity and transparency and credibility in institutions, serving similar to the comments about the Italian role of the prosecutor. Certainly as a prosecutor in Canada, my responsibility was always as an officer of the court, and in conducting my cases, I had all of the obligations to ensure proper disclosure, to ensure that the proceedings were conducted in accordance with the appropriate law and procedures, but also in my conduct in terms of how I dealt with witnesses, how I managed the presentation of the cases, and certainly the obligation to always disclose any evidence of benefit to the accused. So managing prosecution cases, similarly, as a part of a chamber at the ICTY, it was our responsibility to manage the case efficiently, which we did in terms of the size of the case and the amount of time, and managing a large amount of evidence and witnesses, but also to ensure, again, the rights of the defense, to ensure strict adherence to the rules which were designed for the protection of individuals' rights, for the protection of the accused, and the protection of witnesses and victims. So that 4-year proceeding involved always focusing on the institution, the credibility, preserving the integrity of the process. The one other example I would give where basically I had to build the institution was when I became the first ombudsperson for the Al-Qaeda Sanctions Committee, and essentially I had a resolution and I had to implement it in terms of ensuring protections for the independence of the office in a highly political context, putting in place a process and standards that I could apply consistently across all of the cases, and issuing procedures basically in order to guide the work of what is an innovative position premised on the border between law and politics. So there, preserving the integrity was critical to the success of the institution, and that 5 years of experience, I think, also would serve well in terms of those aspects of protecting credibility and preserving integrity that are necessary in a role as an ICC judge. Thanks.
Thank you, Ms. Prost. Ms. Peralta, Distéfano, the same two questions. Thank you.
Thank you very much. As I share with you, as I am a candidate of List B, However, I litigate several cases in my life. I want to put, in my CV, you can see some of the examples. I picked some of them and just name the cases. But I want to just divide in between domestic jurisdiction under the civil system in my country and international litigation. In Uruguay, I represented, I would say, the most repressed demonstration, the victim of the most repressed demonstration by using disproportionate of use of police forces, was a huge demonstration under democracy. And I represent in the criminal system and in the civil system the victim of those that were wounded, and one unfortunately was killed during the demonstration. Also, I brought the first perpetrator of the dictatorship to bring to. I brought it to justice, crafting an arguments that trying to avoid in the amnesty law. But at least I had the possibility to bring the perpetrator to face justice or to face the tribunal. In my international litigation, I litigate a lot of cases. If you can have the opportunity to look at the Center for Justice and International Law, it's probably the organization that litigate more than, I would say, 60% of the cases before the Inter-American system. I was deputy director and the director for the Northern and the Caribbean region, so I litigate cases about police brutality, rape, torture, enforcing disappearance, freedom of expression, inhuman condition in prison, unfair process, protecting measure in the Guantanamo situation. And I want to point out one of the cases that maybe is unfortunately well known. Is I led the litigation of the first case that Uruguay faced before the Inter-American Court of Human Rights. Uruguay never faced a case until this one, and was the Hellman case. I represent the Juan Hellman and the daughter that was the granddaughter that for the first time the court issued that a person can be disappeared for a long time, even though she's still alive, but she was disappeared for the court considered she was under disappeared situation for all the time that she was denied her biological identity. And that was a very pioneer jurisprudence of the court. And the mother, unfortunately, is still disappearance at the whereabouts of she's still in an unknown place, unfortunately. But not only that we gave the reparation to the victim, but also that case had the impact to overturn the amnesty law in my country. So it was a great impact. We litigate with a strategic approach litigation that we try. Of course, our main obligation is to give reparation to the victim, but we work along the victim to try that the case can have an impact in the legal framework of all the country, on the way of the country implement the legislation, the domestic legislation. I don't know if I answered the second part of the question right now, about the whatever is. Okay.
I leave you to decide.
Okay, thank you. In terms of integrity, I'm very aware about all the rules and I mean my commitment and my professional obligation as a representative victim. But I have a lot of I'm very aware not only from procedural view, but also because my integrity and my belief in the rule of law about the guarantee of or the quality of harm, the guarantee of all of the part in the courtroom, and Fortunately, I never have any problem with just trespassing every conduct or every protection of any of the party in a trial. Also, I built up as an ombudswoman. I was the first ombudswoman in my country, and I built up an institution that it doesn't exist before we were elected. So I had to build up the institution in terms of just really literally build up to leave an institution that is functioning, is serving for the inhabitant of Uruguay, and I think I have a lot of credibility. As I told before, I ended my mandate as the chairperson of the National Institution of Human Rights, and in that position, as you may know, the National Institution of Human Rights has to follow the Paris principle. So it's extremely important to be impartial and to issue recommendation and resolution to the different entity of the government and to protect victims in a very fair way.
Thank you, Ms. Peralta. Distéfano. Ms. Mensa-Bonsu?
Thank you very much. I have never held judicial office, but I have been involved in quasi-judicial processes. Truth and Reconciliation Commissions have to hold public hearings, which involves case management skills, and you deal with a large number of petitioners. And managing all those processes in order to come to a successful end itself involves certain courtroom skills. And Truth and Reconciliation Commissions operate in very politically contested and legally contested domains. And so you are constantly having to deal with lawyer representatives and evidentiary rules and making determinations. And then, of course, the assessment of the evidence to determine culpability, and particularly also when there are reparations involved, determining reparations and who is entitled to reparations, and all of those skills come in handy in those quasi-judicial bodies. I've also been a member of the disciplinary committee of the Medical and Dental Council, disciplining doctors. So taking evidence from people who are accusing doctors of malpractice and going through the cases and hearings in the same way as you would in a judicial hearing. I believe that all of those skills are useful skills and create useful experience for real court management situations. Institutional integrity and compliance with rules. Every institution that has accountability as its core mandate has a responsibility to retain the moral high ground. And you don't do that by compromising integrity. You do that by upholding the moral high road and walking the talk. As the Deputy Special Representative of the Secretary General in charge of rule of law, I had to make sure that the mission itself was compliant, so that in dealing with the interlocutors, the national interlocutors, you would have fewer opportunities to have to defend wrong conduct. And you are trying to mentor people to do things a certain way. The least you could do yourself would be to conduct yourself in an unimpeachable fashion. Because if you don't walk the talk, then it undermines the very essence of the work you are trying to do. So compliance with rules and so on, absolutely critical. As a member of the high-level independent panel on peace operations, one of our biggest problems was to confront the issue of the integrity of peace operations, particularly, unfortunately, with sexual abuse scandals and so on, how important it was to revisit the basics and to ensure that rules and other mechanisms intended to ensure compliance and maintenance of integrity were revisited and reaffirmed, because however hard 99.9% of the people work, the 0.1 misconduct can undermine the entire effort. And I think that you are all witnesses. You hear a lot about the sexual abuse by peacekeepers, but you don't hear enough about the other side of the work that the peacekeepers do. But that's because, unfortunately, the few have managed to undermine the work of the many. So I believe that for institutions to have integrity, their own internal mechanisms must ensure that they go by their rules and their principles and so on, and so mirror what they are trying to teach other people by the example, and also hold people to account for not maintaining that level of integrity. You cannot influence other judiciaries if you yourself do not uphold integrity. So it's absolutely critical for the work of the ICC. Thank you.
Thank you, Ms. Mensa-Bonsu. Do we have another question here in the audience?
Thank you very much. Thank you very much for giving me the floor again. My name is Elise Wielema-Gendel. I am with the Coalition for the International Criminal Court. So again, I'm cheating a little bit. And I would like to ask the panel about your experience in applying a gender perspective to the work relevant for the qualifications needed as an ICC judge. Thank you.
Thank you. So the question relates to experience applying a gender perspective to the work of international justice, and potentially explicitly in relation to the ICC, should you become judge there. I will give the floor to Ms. Mensa-Bonsu to start.
Thank you very much. In my work as a teacher and also a practitioner in the international world of international justice, I've had to confront gender issues frontally. A lot of the time, we begin, and that is as it should be, with women's issues, because in situations of conflict, women suffer differently. I always point to the fact that the upsurge of rape after war itself is indicative of the problems that every society has before they go into war, and how the law and order part of the system dissolving then throws up some of the things that are going on in the society. And so when the war ends, it does not end for everybody. It ends for some. It ends for the powerful. It doesn't end for the women, because it goes on by sexual violence. And so one of the cardinal things I did as Deputy Special Representative was to spearhead an anti-rape campaign, which took us all over the country to speak to people and to demonstrate our commitment as an international community to upholding the dignity of women. And in the course of that, it was important to confront gender perspectives, because it became clear that for a war that had gone on for almost 15 years, the young men involved in many of these sexual offenses had not attained sexual maturity in peacetime, but in wartime where there were no rules. And so it was important for them to understand that when peace returns, order returns. And when order returns, then there are specific ways of negotiating even sexual transactions. So that was a very important aspect of the work we did. I also instituted a means of looking at the performance of the judiciary through the eyes of the sexual and gender-based violence cases, and did a tracing of it in order to demonstrate what needed to be done if the judiciary was going to be able to deal with the backlog of cases and raise people's expectations that if they left things to the judiciary, that they would get done. I was also involved in the setting up of a special gender unit for prosecuting sexual and gender-based violence crimes. And my understanding is that it is still going on and it is still doing well. What became clear also in the course of all of this was that a lot of the abuse of young children occurs to boys, but that people are a little more reticent about projecting these, because sometimes, even in war, it's not only rape of females that it is used as a weapon, but rape of males and young boys. And many are then used thereafter as child soldiers, because when their dignity is destroyed, then they become hooked to their attackers, so to speak. And so it's important that in post-conflict accountability, a lot of emphasis be put on gender crimes, because this is the way to make the war end for everybody. Apart from the fact that, of course, in my teaching, I teach philosophy of law, so I teach feminist legal philosophy, and I've done some bit of writing on women's rights and so on. And I believe that with the kind of perspective I have of these matters, there's no way I could undertake anything without paying particular attention to the special way in which events and incidents affect women. Even with reparations, sometimes what affects women a certain way may not affect men in the same way. And therefore, in looking at reparations, some extra effort has to be made to get the women's point of view. Many women, particularly in distant rural communities, receive even information of national affairs through the male filter. And so they are not always able to articulate their own views and so on. And it's important to recognize the existence of this filter. Some cannot speak to a stranger unless they are permitted to by their significant other. And it's important to recognize these things as we design systems so that the women can step forward in safe and secure spaces to have their voices heard. Thank you.
Thank you, Ms. Mensa-Bonsu. Ms. Peralta, Distéfano?
Thank you. I witnessed myself how sexual violence or gender-based crime affected women and men in different way. I think the statute is the first. The statute is the first instrument that expansive and enlarge the list of sexual and gender-based crimes as war crimes relating to both international and national armed conflict, as well as listed up more or expand the list of crime under crimes against humanity, and also in the case of persecution based on gender, when it's amount the crime of genocide. I think there's some things that are extremely important in terms of approach sexual violence and gender-based crimes, and it's not only that it's based on the sex. The crimes are based on the sex of a person, but also on the social constructed role that this apply for men and for women in different way. In the case of approaching cases of sexual violence and gender-based in terms of women, I think it's extremely important to have the knowledge, the skill, the sensibility to apply a criteria that takes into account that not only that those crimes affect differently to women and the role that they play in society and in their communities, but also that is underlying, most of the crime probably are underlined by multiple factors of discrimination in terms of birth, religious, political option, sexual option. So there's a complex social and cultural constructive role that probably are underneath the crime itself and show and it's came for inequalities in their societies. So it's important how the Rome Statute provides are saying that gender would be considered for men and for women, but within a society, and I think it has been a lot of research and statements showing that, trying to go in deep of what that means and trying to understand the different factor that is not only based in the sex or in the gender base, but also extremely another factor that are crossing this stereotyping of the role of especially of women in society. And I think the approach is having a gender legal criteria and the skill, the sensitive, and be very keep in mind to protect and no re-victimize or re-traumatize the person that already suffered those atrocities.
Thank you, Ms. Peralta, Distéfano. Mr. Aitala.
I think my colleague is right. The history of international criminal law is mainly the history of the suffering of vulnerable persons, of the weak, and it's very much the history of suffering of women who have paid double or 3 times men. They've paid as persons, they've paid as mothers, they've paid as wives, and so on and so forth. On Friday, I had my last hearing talking about how many cases, and in this hearing we had a case of stalking, of a brutal persecution of a man against their girl. They had met on the web, and then an awful story of persecution unfolded. Now, at the end of the trial, this guy was convicted. He remained in jail because I opposed that he could be sent to home arrest. I said that he had first to go through a psychological process with a psychologist in order that he could understand exactly and deeply what he had done, because he was excusing himself. I said, no, you need to go through a long process of psychological help to understand what you have done, because we all have feelings such as jealousy or frustration, but we don't become violent. Well, at the end of the trial, what I was thinking when my colleague was speaking earlier, she said that when the international crime are over, suffering in women continues. It came to my mind that this girl came to me at the end of the trial and said, "Can I speak to you?" I said, "Yes, of course." She was shivering as a victim. She was in court, and she asked me, "Excuse me, I didn't really understand what has happened, because I heard that the defense lawyer was saying horrendous things about me, but what's going to happen? Am I safe?" I tell her, "Don't you worry, he's in jail. He will stay in jail. I'm pretty sure he will not contact you again. Of course, one day he will leave jail because he will have served his term, but you don't you worry, nothing's going to happen to you." And, you know, this connects to what my colleague was saying earlier, that, you know, this kind of offenses leave a mark on people's lives. And sometimes it's permanent. In this case, it wasn't that serious. I'm sure she will recover. I told her, "Look, can I give you advice as a brother? Don't you seek for company on the web. You don't need that. It's very dangerous. But I had the feeling that, that finishing the trial, because that was over, wasn't finishing that story. The story was continuing in her life. And this is why it's right that reparation is very important. One last thing about this issue relates to witness protection. Victims, like in this case, are also witnesses. Now, it is right, and the ICC and all tribunals must make sure that witnesses are sincere, that when they sit in court, they don't lie. But we also need to understand that we cannot demand that ordinary people become heroes. If they think that with that testimony back home, their children will be tortured or killed, what would you do? This is what I always think. I ask myself, what would I do? We do have a very complex system of witness protection. In the ICC, it's more challenging because of the geographical problems and many other problems, but this is one priority. If you want to have sincere witnesses who are helping justice, you must make sure that they feel protected and they feel that their families are protected. Because again, we cannot demand that ordinary citizens become heroes. We can choose. I have made my choice. I've made my choice. I take my risk. But it is not their case. They've already been victimized, so we cannot ask anything else. So this is another point where I feel that the ICC could have a progress and should invest on together, of course, and with the vital help of state parties, of NGOs, and any organization or individuals who are interested in this field.
Thank you, Mr. Aitala. Ms. Prost?
The perspective, I think, that I would bring and the important focus for an ICC judge, I believe, in terms of gender-based violence is to consider where we have been and where we are, and to continue the progress which has been made in terms of bringing gender-based violence to the forefront in terms of the ICC statute, in terms of the crimes, but also in terms of the procedural protections and in terms of the rules which are applicable in terms of how evidence in relation to these crimes is protected. So I think my focus in terms of the perspective would be on the fact that we have come from a point where rape and sexual violence in terms of conflict were almost accepted as a part of the ravages of war, to the enormously important case law that developed at the ICTY, including sexual-based violence in terms of crimes against humanity, and of course the ICTR case in advancing it in the context of genocide. So the perspective would be to continue and maintain that progress. We have now seen, albeit it's under appeal, but we have seen the interpretation of the case law at the ICC, and that will continue to be a priority that has to be advanced in terms, again, of the substantive law, but also the surrounding procedural provisions. In terms of my particular experience, I have some exposure to actually dealing with cases of sexual violence from work I did as a prosecutor in northern Canada. So I have the actual experience of the intricacies of that type of case, albeit on a domestic level. I also worked on constitutional challenges in Canada to various measures of protection that Canada adopted to protect victims of sexual violence in terms of how they can deliver their evidence, the use of video evidence, the use of shields. And I also worked similarly on that same area of the law at the Commonwealth Secretariat in developing model legislation in terms of how one deals with the introduction of that evidence. And I think that that's a very important component. During the course of the Rome Statute negotiations, while the Canadian delegation, like many delegations, had different areas of that we were working on, one of the things that we were all required to do throughout the negotiation process was to consider the gender perspective and to consider each of the provisions we were working on from that component, some obviously less relevant than others. And in particular, what I recall and what I think is so important was the achievement not only of including the substantive law provisions, but also Rule 70, which is a very important and critical rule that deals with those misconceptions and the inferences that can be improperly drawn in terms of consent in the context of sexual violence. So as an ICC judge, I would want to ensure that I'm applying all of the tools that have been provided for in the Rome Statute. And also, of course, one of the challenges, certainly when I was an ICTY judge, and it certainly would be the case as an ICC judge, is protection of witnesses and allowing them to testify in a way that they are able to best relay their evidence, that they feel comfortable and safe in doing so, but at the same time ensuring that the rights of the accused are always protected and that the accused has an opportunity to test that evidence. And that's a difficult balance to achieve, but I think there have been provisions, again, built into the statute that allow for that. And at ICTY, even though it wasn't in my case specific sexual-based violence, it was indeed a delicate balance that we had to set in many, many instances of dealing with witnesses and allowing them to give that evidence and at the same time protecting the rights of the accused. So I think with the particular focus on gender-based violence, it would again become a question of setting that appropriate balance, and I would hope to bring that particular perspective from my background in the negotiation process as well as my work at the ICTY and as prosecutor in Canada. Thank you.
Thank you, Ms. Prost. Well, I think this concludes our third panel discussion for today. I would like to thank the panelists from this session, Ms. Peralta, Distéfano, Ms. Prost, Ms. Mensa-Bonsu, and Mr. Aitala, as well as the participants of the two previous panel discussions, Madame Alepini-Gansou, Monsieur Vukoye, Ms. Akane, Ms. Ibanez, Ms. Majara, Ms. Bossa, Mr. Devic, and Mr. Chagda. It is also, once again, a privileged honor to thank the host state of the Netherlands, particularly the Ministry of Foreign Affairs, the Ambassador van Ijssel, and all of his colleagues here for, once again, allowing us to have these panel discussions in this setting. My sincere and extensive thanks and gratitude to the interpreters once again for staying with us this entire day. And also, I would be remiss if I did not acknowledge the tremendous work and contribution of the audio-visual technical team here at the Ministry, who have made the live streaming and recording of these panel discussions possible. Chapeau, as one would say in French. I also would be remiss if I did not thank my dedicated colleagues, staff, and interns in the Coalition Secretariat here in The Hague, as well as in New York, who have been tremendous in putting together this campaign and today's discussions. And finally, a big thank you to the audience, those present here in The Hague, but also those who have followed these discussions from afar, I hope from all around the world.